we'll get started. So we are here today to discuss Article 1. Was everybody able to access the Google document? Okay.
I don't think I wasn't.
You weren't?
Mm-mm.
All right. It says it's shared with you. I had this trouble with the other committee I'm on, but I just couldn't do it from my city council email. I had to use it had to be shared to my Google. Let me look at it.
Yeah, I was able to look at it, but I wasn't able to comment. But then
when I shared it with your Gmail, did I share it? I think I shared it with your Gmail account. Were you able to?
I looked at it because and at one point I couldn't see your comments, but now I have it up and I can through my Gmail account.
So, and that's the problem I had with my other one. I kept trying to do it from the city link at my city council. And I think because I have Gmail, it just wouldn't. And then someone's like, go incognito. So I did that and it still didn't work. So I can only do it through my Gmail account.
Yeah, but now I can see your comments and the links and everything.
Okay.
Yeah.
Stefan, let me see. Okay, how do Sarah, you might have to help me.
Yeah, no, you're good. If you click on share in the document.
All right, it'll tell me. Yeah, so it says, Stefan, it says you're an editor.
Okay.
Go ahead and use the, I think I can do it because I'm an editor.
Yeah, thank you.
This. I'll update the permissions for this meeting and I'll drop the link in the chat and that should work. But yeah, well, actually, you know what? I can't get into my Maplewood email this morning.
I couldn't either.
Okay.
So, all right. Do you?
But let me. I can resend the email. Oh my gosh, Google is not my friend this morning. Okay, so the link to the Google Doc is in the Zoom chat, and then Stefan, I just emailed it to you again. So it should be coming through soon.
Zoom chat. Okay.
Yeah, it'll be in the chat and in.
I'm clicking on it now.
Okay, cool.
Well, I'm clicking on it anyway.
And I will remember to change the permissions on that before we leave, just in case.
Okay. Thank you.
Slowly but surely it's coming up. Like Niagara Falls.
Are you hearing that like dial-up tone in your head from the old days of internet? When I had to run my telephone cord down the hallway.
Okay, I see 34-1. He's even highlighted. Okay.
Yes. So before we start, I'll just tell you what I did. And I'll be honest, I didn't get through. There are a couple I still didn't get through, but I basically went through and I looked at Webster. I looked at Brentwood. I looked at Richmond Heights. I looked at Clayton and I looked at U City just to kind of get an idea of sort of what their ordinances looked like and compared them. And I noticed that it appears Brentwood, U City, Richmond Heights, and Clayton for the most part, although Clayton must have been the first because theirs are a little different, all seem to use like the same ordinances basically. Or the same company created their ordinances online because they all sort of are named the same, look the same. And so I just sort of went through for each one and noted what theirs said and in comparison to our, or what theirs said, how it was different. Just as a frame of reference, because theirs clearly have been updated because a lot of them match state law, like ours don't and theirs do. So anyway, how do you guys want to start? Do you just want to, does anyone have general thoughts or do you just want to kind of go through one at a time? One at a time.
Yeah, I'd say go through one at a time.
Okay.
Okay. At least because we can at least
Get started.
get started and highlight the ones that we think,
Okay.
maybe we delete or need significant revision.
Okay.
Mhm.
And I still haven't heard from Chief Nyber, but I think they've had a busy few weeks, so I'm not surprised.
Yeah.
So I think for a lot of these too, like where I've suggested like delete, like, or is it necessary? We will still have to run by and ask him. But the first one, 34-1, he, I think, said when we talked last time, this one was unnecessary. And I think we all kind of thought that it was potentially dangerous. And so my thought is to delete 34-1. Did anyone else? Do you guys?
It works for me.
Yeah,
Agreed.
I agree with that entirely.
Okay. So I'm just gonna, I'll make comments on this. All right. And so that, like, what our outcome is. All right, so delete. All right, so next one, I found in chapter 1, section 113, there's like the same ordinance that covers the whole code. So I guess to me, it seems unnecessary to have 2 of the same ordinance. And so I thought maybe this was a question for Matt and Jackie, like which do they use if they use this one? Because I don't like to have 2 of the same thing. And if chapter 1 applies to the whole code, then it would apply to this article too.
Yeah, and
Now,
I would
whether-
I would think that chapter 1 does. Sorry, Kevin, go ahead.
No, go ahead, Sarah. Sorry.
Oh no, you're fine. I agree. I could see a world in which, like, because there are 2, you get charged for violating both, which I would not be in favor of. Like, that's kind of stacking, in my opinion, violations. And chapter 1 is designed to apply to the entire code. It's that whole like penalty section.
Yeah, I was going to say it would almost make more sense. It seems to almost delete that section 113 and keep this in the violations, just kind of from a logical standpoint.
Yeah, I mean, you're like, because what do you aid and abet in the other chapters, kind of?
And yeah, if you're aiding
Yeah.
and abetting in the violation of any city ordinance, then that
So
would be
that's-
here in the offenses section.
So that's why I thought maybe that might be a good question for Matt and Jackie, because they're the ones, Matt's the one issuing the ticket, she's the one, so okay. I'll know which place makes more sense. And I'll ask, okay, we can ask them, because I agree. I mean, I don't know if you aid and abet in violating park hours, so like it may not make sense to have it there. All right, cool. And also, do you have any comments sort of about the way it's worded? Any issues with it too as we go through this? I didn't see anything, but
Yeah, I mean, I would just say that, typically my understanding of aiding and abetting would be you're aiding and abetting in a criminal offense or coercing someone to commit a criminal offense. So, kind of keeping it in the offenses section, it could
Okay.
be it could be worded something to the effect, to be a violation of, any of the, in violation of chapter 34 or something like that, as
Okay.
opposed to, violating a coding ordinance or something to that effect.
right. And I'm not sure I want to feel the need to charge someone with aiding and abetting like, you know what I mean? Yeah, I agree with you. It seems to be a design for
How does that fit with state law?
So I didn't find, I guess, I don't see a note, so I didn't find a state law. And I didn't notice this one in any of the other ones. I didn't specifically look. I don't think I checked this one yet, but I don't think any of the other ones, like the other municipalities had an aiding and abetting unless it's in like a general section in the beginning. I didn't see it in their offenses section. But Matt and Jackie did say this is one they utilize, I believe, when we met last time. They like to have this one. I think they referenced maybe like with shoplifting or stealing or so. I don't have a particular problem having an aiding and abetting charge.
No.
No, and I think the way it's worded is pretty comprehensive. I don't see
Yeah.
anything that
Yeah, I didn't either.
stretches it too much.
Okay. So if everyone's good, the next one is obedience to lawful orders required. This one, I wrote down notes, but I didn't get them in the document. So Clayton has a failure to comply with the order of a police officer. Webster and Brentwood didn't have anything. Richmond Heights has I can't read my own handwriting. Willfully failing or refusing law enforcement and a failure to comply. And then U City has a failure to comply. So it may be there's a more I'd kind of like to see if there's like a more modern way of saying this. This seems to me, I guess it has to be a lawful order, but potentially dangerous. Like if a police officer tells you to do something that's not safe for you.
Right.
So I guess that was, and I didn't get to it. Clearly I did not do them all in order, but I'd like to see maybe if there's some other language for this. Or
Yeah, and I think the like willful failure to comply is a good point. So I think about this kind of like order from an officer in the context of like protests. Sorry, I don't know if you can hear the dog just like making the most atrocious sound. Like, so, if a police officer, orders protesters to disperse, but you like reasonably can't hear them. And so then you're now in a position of like failing to comply or follow an order. So I think the willful piece is really interesting. Like that would require some measurement of the individual heard what you were saying and they understood what you were saying. I'm kind of interested in that angle.
Yeah, I'd agree with that. Like, it's one thing to say, a police officer says, "Get out of the car. Can you please get out of the car, sir?" And the person says no, or there's just some type of general announcement that, a person might not hear or might not understand as well.
Right. That's a good point too. Okay, so.
Yeah, I guess it looks like the key there is obey a lawful order. If it's a lawful order but doesn't apply to the situation, is it truly a lawful order? Or is it a trap? And so that's some other kind of clarifying language might be in order.
All right, well, I can, excuse me, I'll look and see what those other ones say, and then I can add it to the document, and then, maybe we want to look elsewhere too. We don't have to stay around here. I just thought that was useful. It's like you have to start somewhere, starting point, and then, if we don't like that, we can always look broader. Okay. Yeah, because I think when I first read that, I didn't love it as it was written, but I get the need possibly for it for certain situations. Okay. All right. Moving on here. 34-4, refusing aid. This one, So this one I feel like could be potentially dangerous to an individual. Like what does that mean? And how is that different than the last one?
Think about the case we learned about in class where you have 34 witnesses, but nobody saw the crime,
Mhm.
and the police are attempting to compel cooperation
Mm,
with the threat of, refusing to assist or hiding, withholding evidence, whatever, because you did not respond to our request for assistance. And so, what does it truly mean to refuse aid? We don't know what aid, we haven't defined aid.
mhm.
So, and refuse or neglect, omission and commission. Um, Again, clarity.
I will note, sorry, I forgot to add this to the document. I'll add it now. Oh, no, I did right. It's not used in any of those 5 municipalities I looked at.
Yeah, it's not like they're trying to deputize somebody. I'm not sure what it's about.
Well, and like, I guess for me, I think it goes back to the last one, like, I don't know, a safety issue. Like, what if the officer tells me to help them do something and I don't feel safe with that, and then how does that run up against, is that a lawful order? Like, that's where I think there's some potential confusion too, is that there's one right before it. And then this one, they seem like they could overlap in a way. I would be fine deleting this one, but
Liability. The person who assists at the
yeah,
request of the officer becomes injured.
yeah.
The officer then place the city at risk, or liable for the actions of the officer. Is there some other problem associated with that? It just kind of gets a little garbled.
Yeah, this is the one, the one section that I had thought could be deleted
All right.
entirely. For, the reasons stated, and it's, I mean, it's one thing if a police officer gives a lawful order to you to to do something or stop doing something and you don't do it. But, I don't think they should be able to compel you to take, a certain action in, assisting or aiding an officer in doing something.
Okay, good. I agree. I think we're all get rid of it. Let's make this shorter. All right. Let's see. So then interference with police officer prohibited. This one I just added right before. The only 2 of those that had something were oh wait, Webster has one too. But Brentwood was the same. I think Webster's is kind of the same too. They combined theirs with another one. But then U City had one that extends to all city officers and employees. I don't know. Or at least the inclusion of a firefighter, I thought was interesting that in theirs, maybe not all employees. I mean, I'm not looking to expand the ways that we can penalize people necessarily, but I just put it on there as thought, food for thought.
Yeah, I think again, this gets really I like the inclusion of firefighters, right? Like they're on their way to stop a fire. Like you shouldn't use your car to block them from doing that. I agree. The police thing, I think, is the police side is tricky for me because I just keep thinking about it in the context of protesting, right? And there's a difference between an interaction with a police officer who's who's like on duty out like at the protest versus like a cop car that needs to get through to respond to like an unrelated emergency. And I don't think you can draw that distinction here, but I could see how like this could be used inappropriately.
When I
think
know of an
that's my
incident
concern.
too, where like there was an unhoused person and someone was trying to help them and the police came and then the person was like, hey, you're being kind of rude to that person. And then they sort of like, do you want me to charge you with interfering? So again, I'm with you on that. I'm wondering, is this one where maybe we look further afield to see if there is some more language that can balance those things?
I would, and it might be a good idea to put that in front of Nyber and ask him what he thinks.
Yeah, I think all of these, I think it'll be helpful to show all of these to them, and we may not agree in the end on all of them, but just to get their thoughts. All right, so possibly adding firefighters, because I kind of did like that, and then look. All right.
No, there's firefighters and then there's EMT.
Right.
You could broadly say like emergency services.
Yeah. I think we're probably going to have to, because one thing I noticed too, I think, we're doing like the substantive part of the ordinances, but there's also sort of some organizational stuff within the ordinances, how they're set out that I think we might need to do, because like this Article 1 and everyone else's is just like definitions, which I think it might be helpful to have a set of definitions in the beginning. And then there's like a lot of these are like, what do they call, like crimes involving administration or something. They're more so I think maybe separating out that way would make sense. So yes, Sarah, I agree that
Yeah.
all right. Yeah, I can't type this in. What is wrong with me? All right. Okay. Any other thoughts on that one? No. Okay. Impersonating police officers prohibited. This one, as I noted, 4 of the 5 use like just a false impersonation, and it actually matches the state statute. So I'm just thinking this is one that, was passed in 1982 and it was never updated. I don't know if I imagine that Matt will want, I think he made that comment wanting to update these to match the state statute. And I did like, I think in some Richmond Heights especially, we'll have a footnote that will say this can also be a felony under state law, which I think is kind of a nice footnote to have, just to warn someone. I don't know, just to have that, because the state statute will say, it's a felony if, and that's left off the ordinance added to the municipality, but then they'll footnote it and say this is potential felony also under state law. I don't know if you've even had a chance to look at those ordinances, but are you in favor of updating to match the state statute?
Yes.
Yeah.
Yeah. Yeah, I looked at the state statute and I agree matching it or updating it would make sense.
Okay. All right, let me put a note there. Ever since law school, I cannot distinguish statute and statue. I have the hardest time with those words. Anywho, all right. All right, so the next one is false declarations. It looks like the state statute maybe was updated since this was passed, and ours just hasn't been. I noted the places that were different. And I guess one is just a statutory reference in it, and then one is just referring to an actor or person. But then the last one was including electronic documents in what a writing is, which seems to make sense. So would you want to update this to match the state statute?
It should, does the, I now haven't looked at the state statute. I guess one of the things that appears to be a pattern, as they say, is the use of the word he.
Yeah, I had a general note.
Of crimes, you know.
I had a general note to update it all to gender neutral language. And so I don't know, there's probably a way you do that in ordinances, you know.
Yes,
I think
Yeah, and the state statute does refer to he or she,
yes, they do he or she.
or just refers to the person, you know.
That
Person.
person, yeah, person seems to make sense to me.
unless we feel that if we meet the state statute at minimum, or if there's something that I guess I need to look at it and make sure we don't feel like there's anything too stringent about the state statute that should be decreased.
Yeah, the only difference between ours and the way it is now is that they've updated the state one to include electronic filings in writings, which makes sense since I'm sure most things are submitted electronically now.
And I'm good with it.
I mean, it seems like if we're going to have it, it would make sense for it to include that. But,
Yeah.
Okay. You know, and this baby one, they honestly don't really use, but they just want to have in case. I don't know. I'm trying to think what, you know, sort of an example of this. I guess if you're give a false statement to an officer with that.
Or if you're filling out permit information and
Right.
you make, you know,
Mhm.
affirmatively
lie.
fraudulent and false statements in an application
Yeah,
in order to, you know, to get a permit or to get some type of benefit
yeah.
from, you know, from the city.
Yeah, and I'm thinking in 1982 that they did not, it was all on paper.
Yep.
So, okay, all right. So I'll note we can update to match that. The next one, did anyone have anything else on that one? No. Okay. The next one, this is the exact same as the state statute. So, unless anyone has any sort of issue with it substantively. I think it makes
No.
sense. All right. Let me just. Okay. All right. The next one is escape and aiding in escape prohibited. So what I noticed, my first question is, I don't know if you need the aiding and escape if you have an aiding and abetting ordinance. So it would, and none of the other ones had it, the ones I looked at, the municipal ones, which probably because they have maybe they have a general one somewhere else. But the difference is where there's either sort of aiding or escaping from custody, and then there's what two of them were, and then some were escaping from custody and confinement. And the confinement piece, I think, is like electronic ankle monitoring is what it seemed like from the state statute, because the Richmond Heights ordinance, or maybe it was the Clayton one, had a link to the various statutes that were relevant. And that's what I saw, is it seemed to go to electronic monitoring. And so I guess our question is, one, would you want to include that? Would you want to keep this the same and just take out B, since we have aiding and abetting, or update it to match these. I think these are, let me look at them.
So I agree that B is likely redundant, right? Like aiding and abetting should probably be inclusive of specific examples. I also feel like A may be redundant under this, like the lawful order piece, right? Like if you're being like lawfully detained. Like I'm having a hard time kind of mapping the Venn diagram of following a lawful order and escaping, if that makes sense.
I think to me, the difference is the lawful order would be like in the act of interacting, but then once you've been detained, you're in custody, which is different. And so it's just, so I would think you wouldn't be able to use the other one, you know, unless the person said, stop escaping, you know, like that would be a lawful order,
Right.
maybe, but I don't know.
Well, that's how I would distinguish them. B, on the other hand, would have to go.
Yeah,
I don't know what
Okay.
rescue means.
I'm trying to think, see if, I don't know if the others are very different from ours. Sorry, some of these I was going quickly. Oh, where is it? Okay, the Clayton ordinance is custody or confinement. So I also like how these, and I think that's because they follow sort of like the way the state statutes are written. It just says a person commits the offense of. I kind of just liked that better than our, I don't know. But anyway, escape from custody or confinement or attempted escape from custody or confinement if while being held in custody after arrest or confinement, after sentencing for any offense, he or she escapes or attempts to escape from such custody or confinement, including but not limited to by means of intentionally removing, altering, tampering, or damaging electronic monitoring equipment with the court, which a court has required such person to wear. So that's custody and confinement. And then just custody, I think just kind of reads like ours. A person commits the offense of escape from custody or attempted escape from custody if, while being held in custody after arrest for any offense, he, she escapes or attempts to escape. That's simpler than ours. I think it's, is it me or I just kind of like the way those are worded better.
I'm looking at the U City one right now. And I think it's just clear, you know, stating if while being held in custody after arrest for any offense,
Okay,
she escapes or attempts to escape from custody.
okay. So use update the maps. You like that one better?
Did you read something about escaping after as a result of being in court?
Just being, it would be while being held in custody after arrest for any offense. So if you're, so, you know, if the police officer places someone under arrest and then, you know, whether the person's, you know, in jail or in a police car or being transported and they,
That's what I'm saying. If they're in court, under the jurisdiction of the court, although they under arrest, are we still considering them under the arrest of a police officer if they attempt to escape while in court? If it's municipal court, that they are still going to be covered by this ordinance. But the court has the ability then to impose penalty for an attempted escape.
So I think that maybe that, so maybe I'm wrong, but that wouldn't happen because in Maplewood, the way I understand it, if you're arrested, you're taken to, we share the facility with Richmond Heights. The judge comes there and arraigns so you're never, while you're in custody, you're never brought to municipal court, like to the physical court space. You're in the jail and the judge comes to you. Is the way I understand how it works now. And then, you know, I think Matt made the comment, the most they can hold people is like 2 or 3 days. And so I'm gonna guess the other thing is in some of these, there is also state law. So they could always charge them with state law violation and then just turn them over to the state court. And that's maybe where I'm not sure it's necessary to have the confinement piece, the electronic monitoring, because there is a state law that covers that. And I don't know
And the
that,
municipal judge isn't gonna impose
no,
that type, if it's that serious of an offense, I don't think
The-
it would go to the municipal level, you know?
right. And I think the goal is like with some of this is like, maybe the municipal offense is a little bit lesser of an offense. So maybe trying to help someone, keep them out of the state court system. But like, if you're removing your electronic monitoring device after you've been, like, maybe that's just, we leave that with the state court and we don't need to mess with that kind of thing. But I don't,
Okay.
but so U City, I have no, you liked that U City one. I didn't put that link in there, sorry. And it just said after arrest. So it was just clear. Like it was just after you're arrested, there was no.
After you're arrested for an offense,
Okay.
you know, and then
Okay.
you try, and then you escape or
Okay.
attempt to.
Attempt to. Okay, cool. All right. So I'll note that. Sarah, you cool with that? Okay. All right. All right. So the next one was resisting or interfering with arrest. Let's see. Yeah, so Brentwood, Richmond Heights, and U City all use the same ordinance. They extend it to detention or stop as well, and it matches the state statute. Clayton's was slightly different, but I got the impression maybe theirs was first and they just haven't, and maybe there was a change to the state statute after they passed theirs and just wasn't updated because it was not a huge difference as I recall. Let's see. I just think it was clearer. I think it was just better written, maybe. It doesn't seem. It does also have this C, which is new. It looks like a person is presumed to be fleeing a vehicle stop if he or she continues to operate a motor vehicle after he or she has seen or should have clearly or seen clearly visible emergency lights or has heard or should have heard the signal. That looks to be the main substantive difference between ours and the modern updated state statute.
So C in this 3410. This is the C you were talking about. Is there a difference?
No, I'm sorry. I clicked on the, if you click on the link for the U City ordinance there in my comment.
See, I was looking at ours.
That matches the state statute. So that I have a feeling when ours was written, this is what maybe the state statute looked like. But that since then, since it was 1982, it's been updated. And I was trying to see what the differences were. And I think the differences are it's extended to stops and detention and not just arrest. I know you can have with the stop thing, there could be some, we've talked about that before. I mean, I guess the question then is it's the different, I mean, under state law, they could always charge them with that under state law. So it's whether or not we want our municipal ordinance to match, which my guess is the police would prefer it did. The question is, do we as a community want it to.
I mean, to allow an officer to complete an unlawful act and still hold the subject liable or, to be submissive to the officer's unlawful order is, I'm thinking of the traffic stop. And that's, I guess that gives me a little bit of a pause for the person who refuses, for example, the search of their vehicle, or refuses, and is still directed to do so, and the officer does not have cause which to make that request. So the rights of the individual then conflict with the unlawful order of an officer. And if I read this correctly, it is saying that the rights of the individual are not applicable even to the right to an unlawful order of an officer.
Well, it does, it does say that at least I'm looking at the U City one, that it's to lawfully detain or stop an individual. And, if there is an unlawful stop or an unlawful search, which hopefully there would not be, but unfortunately there are, the individual would still have, be able to assert that defense, or even, a civil action for violation of civil rights. It kind of falls into the difficulty with a lot of these sections is, given making sure the police can do their job when it's really a bad person or a bad actor doing something, and then also trying to protect if the police officer is being the bad actor and and you have an innocent person involved.
I guess, it's problematic because state law says that too, right? So under our state law, it's saying you cannot use the fact that the officer was acting unlawfully as a defense to your prosecution, which I guess has passed constitutional muster. But what does that mean? So then I'm trying to think in the context. So Stefan, to get to your question, like what you're saying is like, you can't be like, this needs to be thrown out because they were acting unlawfully, which to me is a great defense. Like they didn't have a reason to stop, but I feel like that should. So I guess my question is like, this is already a state law. And so the officer can always charge the person they stop with this. It would just be a state violation instead of a municipal. And I guess I don't really understand what that means in the context. Then if you are arrested, you do resist arrest or interfere, and they've acted unlawfully, what is your defense then? I mean, I don't know if we're going to answer that, but like, that's just a question generally in the state of Missouri.
Yeah, and if you say, no, I don't give permission for you to search my vehicle, are you then resisting arrest?
Yeah, and that's, and I feel like that might be like a case law kind of question. I don't know.
Well, under this one, it would be, I think it would violate it if in saying, no, you can't, if you search my car, I'm gonna kill you or something, because it seems like it's 1 and 2, at least I'm looking at the state statute.
Yeah.
It's, premised on the person is using violence or threatening violence or physical force when they're resisting the order.
That is correct.
So I think if they're, if you're just saying, no, you can't search my car,
Yes.
or no, I'm not gonna let you frisk me, then I don't think that would be a violation. That it's.
And you're right, Kevin, and that's the answer. It's saying that I feel like the crux of this is you do have to commit some threatening use of violence or physical force or flee. That's the only way your chart can be charged under this. And so, Stefan, to get to yours, is they're saying that the fact that it was unlawful does not excuse you from using violent or threatening force, but you could still sue them civilly for unlawfully stopping you, right? I think that's what this is getting at.
So then it should say that, or we need to remove C. It should either state that plainly or be rid of it.
What you see in ours?
Yeah, ours.
Well, no, I mean, that is what it's saying. So if you look
That's-
at A, the only way you can be charged with this, like Kevin said, if you just say no, that doesn't fall under this ordinance, right? If you just say no, you're just saying no. But if you say no and you push the officer away, right, then you could be charged with this, it sounds like. Or if you threaten them. Now, granted, I know there can be he said, whatever, but if you threaten them, then that also, but you have to threaten the use of violence or physical force, the way I read it. If we followed the new statute, ours, yes, it says the same thing.
If you try to get into my car, I will sue you. And I put my finger up. I guess I'm just saying is.
But is that threatening violence,
Okay.
physical force, or physical interference?
That's the
I think
question. Either
yeah,
the ordinance is plainly stated as opposed to assumed, or it's not stated, or it's not part of the ordinance. I guess is what I'm driving at.
yeah, I think like what's kind of the rubber hitting the road for me right now is using or threatening the use of violence, right? Like that's not something that we can very black and white measure. It's going to be dependent on the officer and the interaction, which leaves a lot of like flexibility that I'm not comfortable with. And so it sounds like most of the munis around us use the state statute, but I'm wondering if we could look broader and see if there's something that's more clear.
Yeah, I was just going to suggest that.
okay.
Yes, we can look and see if there has been anything. Now, I will say then, it doesn't mean that they still can't be charged under this particular set because there is the
Right.
state statute. But yes, I
Yep.
am in favor of looking and seeing if we can find.
Yeah, I
something
mean,
else.
and maybe, and maybe it's just whether we just want to strike the threatening the use of violence,
Yeah,
you know, because
by
it's, you
using,
know,
yeah,
it's kind of a clear line if they use violence, you know, if they've, you know, pushed an officer or struck an officer or something like that. But then, you know, there is the vagueness with respect to, you know, what is threatening, you know.
right.
Since we don't say anything about proximity to threats and things like that.
Right.
All right.
Yeah, and I think too, just, and this is maybe more of a general comment, when we're looking at like these types of ordinances, I think that realistically, I think it's unlikely that someone is solely charged for a municipal violation of aiding and abetting or you know, threatening an officer, interfering. Like I think a lot of this will ultimately rise to the state. And so the position I think we're in is, are we creating a situation in which someone is charged at multiple levels for the same offense? And like, I'm no lawyer, so I don't feel like that should be allowed, but you know,
They
Our prison
can't
also-
charge you for the same crime under, I don't think, under the municipal and the
Okay.
state, right, Kevin?
Right. I
Yeah.
think it's all, once
Okay.
it goes to the state, it's up to it'd be solely in the county prosecutors, I believe.
Okay. That makes me feel better because I was just like, this is a lot, right? Like you do one thing and now you're going through municipal court and circuit
Yeah.
court,
Yeah, that you're just stacking.
Yes.
Yeah.
right?
Now, someone
Ah.
they can be charged both federally and at the state level, I think. But you know, if the feds are charging you, you're in a whole lot of trouble. So we don't have to worry about that.
Yes. Okay. So we'll broaden our search for language that more clearly. All right. I'm just going to say broad. I know what we're doing. All right. All right. Yeah, I think that was good. Anything else on that one? No. All right. So next one was interference with legal process. And so they were all the other municipalities sort of were generally phrased the same as ours, but I think I saw Brentwood was phrased the same as the state statute, and it seemed to be phrased the best. I just think it was more clear, like the order of the wording was clearer than ours. But I mean, it's substantively, I think, says the same thing. Because like ours puts it puts the, you know, it switches the order. It makes it a little unnecessarily confusing, I think. So.
Yeah, I like Brentwood's. Maplewoods reads like an academic paper that I'm trying to meet a deadline for and try to hit a word count. So I would prefer just more straightforward syntax.
Yes, and I didn't like Richmond Heights had an additional provision about making him. I didn't like it. It broadened it to like your employees have to accept process. I don't think we need to go there. Personally, they must get a lot of process served in Richmond Heights. All right, let's see. All right. The next one was conspiracy. And, you know, I never got through all this one, but I think I only saw this in one other municipality. But I did not, this is one I never got all the way through to seeing. I mean,
this is one I would say that if they have ever, I can't believe that someone has been charged with conspiracy in Maplewood. If it's at that level, I would imagine it'd be at the county or federal level. And that
I would agree. Delete. I would be
unless the prosecutor or Chief Niver have a good reason to keep it.
That would be my vote. You guys good with that?
Yeah. Now, early on, I had mentioned that part of the ordinance that deals with housing and the penalties for violation of whatever our housing ordinance becomes, if it reflects federal or reflects state, which is two different pots. But one of the catch-alls in the federal law is to otherwise deny or access to fair housing and or to interfere, coerce. And so the question became, one of the questions was, if more than one individual is involved in denying you housing, what do we have? So do you conspiracy? Do are you going to just call it interference or coercion? So I mean, not that I have a problem with the definition here. I'm just saying, municipally, what would the city do in response to someone making a local complaint of housing discrimination? Are they going to try and boot it to the county, or tell them that they need to go file with the federal government or with the state? I don't know. if the local is going to handle it, then the definitions between what might be in the ordinance for housing versus this one here.
Yeah, and I do know that, like, with respect to the Missouri Human Rights Act, which would cover employment and housing, that it's that it states it's an unlawful discriminatory practice for anyone to, like you said, aid, abet, or coerce anything that's in violation of the act.
This change.
So I think and I know that the housing, and I think the human rights or code is also being updated, and that would be the place to have that, because I think those would be I guess those would be civil offenses as opposed to criminal offenses. Or I think they could still be brought. They could still be, I'm just trying to think through the city could still take action, but I don't know if it would fall under this chapter, whether it be in another chapter where the city has recourse for someone, violating, whether it's Housing Act or any type of discrimination or retaliation based on protected classes.
That was my thought too, was that with that, because if we leave conspiracy here, it's applicable to sort of all these criminal offenses. I don't know. I mean, it's not clear, but I would think so. Stefan, my thought was with Kevin is that would be a civil penalty. Are you saying under state law it can be a criminal penalty?
I'm saying that the state law and the federal law, which used to be the same, have changed.
Right.
Because of legislation in the state.
Yeah, shocker.
My example to you, I was thinking in one when Sarah was talking about stacking.
Yeah.
Thinking about the cross burning. It's not a civil issue.
So
deny house, that becomes
gotcha.
an issue. So a group of individuals are involved in the burning of the house or shooting through your home. I
see. So the question then maybe is where the state has taken away some of that protection. Do we want to add it back in at a municipal level? Right? Yeah. Is that sort of the idea? Yeah, the state's a little different. Gotcha. I'm sure it's less than, right? Is my guess. Yeah. Yeah, they are no longer compatible with the federal law. I think that's a fair point. But when Sarah was talking about stacking, I was just curious to know, you're going to be charged over here under this ordinance and then charged with something else, and then I was just curious. Well, I think to answer your initial question is, would the city of Maplewood handle it or would they not? I think the honest answer is at this point is I don't know that they have any process for handling that. I'm guessing they would refer it on. I think right now they're in the midst of it. I mean, they have a fairly involved ordinance for housing, that I've read. It's very involved, and in some instances it meets with state, in some instances it meets with federal. They need to be revised, but so I was just curious. I understand it is generally an administrative violation, except when someone cross burning, that violent act takes it into another realm. If it is local, is there going to be a local response? And if there's going to be a local response, I guess I have another question. Is cross burning a specific ordinance or law that you violate, or you're saying it would just fall? Because that's my question. So in that sense, you're saying it's a criminal penalty, but we don't have an ordinance that says that. So I guess that's where maybe a disconnect is too, or am I misunderstanding? There's a catch-all that says, or otherwise deny them
access to fair housing. And that
Right.
is just that, a catch-all. So for individuals who would ordinarily think that they were exempt from coverage under the law, they can be caught
Right. Right.
and actually not be exempt. But they can also then, it can then fall into other statutes. That would be a federal statute, for example, where you can bring charges in a couple of different places. I guess what I'm driving at here locally is if it is a local charge, if it is a cross burning, if it is a whatever, it could potentially be, is that considered a crime to drive somebody out of their home if you shoot through their house?
Ah, I got you.
Yeah, I mean, yeah, that
That
would be a,
Yeah.
it would certainly be assault.
Yeah.
And
So also,
you know,
I guess I'm thinking, are you stacking these things, or is it just going to be one?
And
I
I
mean,
guess
for an act, for a single act, you can be charged with multiple violations. So if, like you said, if you shoot through
Yeah.
someone's home, which I think in reality that's going to get passed on to the county, but that would be, I assume that there's something about damaging somebody else's property. You've
I'm
got,
sure.
you've got assault. I
If
think
someone helped you, you have aiding and abetting. I mean, conspiracy is the planning, right? I mean, that's the preparation and the
is
planning.
the meeting of the
Right.
meeting of the minds, and then I think we've got there might be a vandalism,
Mhm.
which I think it would kind of touch upon some of the same issues. If you have someone who spray paints something highly offensive on somebody else's or on public property.
I mean, basically, I'm just curious to know if there's going to be a local response with ordinances like conspiracy and with a housing discrimination, ordinance. That's all.
I think I think conspiracy here, I think like Kevin said, I'd be really surprised if Maplewood has ever issued a municipal ticket for conspiracy as it's used here. But I can see the need you're raising perhaps in the housing ordinance that we make sure that anyone conspiring to do that or participating in those actions is also charged. Whether or not Maplewood handles that or not, I guess that's an administrative question. I'm not sure that how many complaints they've gotten. I'm not sure, to me as part of, I think that's Sarah's chapter, that's part of her work with her group is setting that up and figuring out what that looks like. Cause I'm not sure it's even clear in the ordinance what happens.
To throw another wrench for the Columbia ordinance, which I was a part of, a violation of the Columbia ordinance with regard to housing discrimination is a misdemeanor crime, punishable by fine and or jail time. And so it's a crime.
Yeah.
So, in addition to whether or not it's administrative, if you want to try and settle it administratively. However, in theory, if you are found in violation, you're actually found guilty of violating the ordinance. And so, again,
I gotcha.
I don't know where Sarah's group's going, but I just throw it out there. When we have, a section called conspiracy.
Yeah, and the enforcement, and I may have mentioned this last time too, the enforcement piece of the housing chapter is the toughest part because currently it's assigned to this committee that doesn't exist. It's a commission that like I can find no trace of. So even if we did, and so it needs to just like my general opinion tends to be that it needs to be away from like appointed or elected individuals and instead in the hands of staff. And so there's at least some like administrative consistency and that sort of thing. But yeah, the enforcement piece of that chapter is the toughest section because you're right, like in a lot of ways, that section already aligns with state, already aligns with parts of the federal, and so, making sure we've got our bases covered at that part of who can be discriminated against and on the basis of what part of their identity, that part, like we're in pretty good shape. It's the actually like enforcing part is incredibly challenging.
Mhm.
I agree.
So my thought is with conspiracy here is we can ask Chief Nyber about this one's use. We can sort of, bracket it for now and see maybe if Sarah's group, if there's a need to keep it here or if we would want to move it. So we can just sort of leave it for now and revisit it. Because I think there's going to be a lot of that in this where we may have to just put a pin in it for a minute and then come back and look at it in a greater context. Does that make sense?
Yeah, it's fine with me. I'm happy with
Okay.
it.
All right, so I'll make a note to ask Chief Nyber about it. What's your chapter number, Sarah? No, all right.
Like 32 or 30. I think it's
Okay.
30.
Oh, is it 30? Human relations?
Yeah.
Yeah.
Yeah, all right. All right, great. All right. Ooh, are we on the last one? This one, this to me seems, these next two, they don't need to be separate. I don't know. I don't think. I think they can be the tobacco and electronic should be combined into one ordinance. I'm not sure why they didn't do that when they did this. Ease, I don't know.
Agree.
I think this is one we may want to all kind of look at and revisit, but because I didn't get a chance to really go through and compare them all. But one thing I did know is that 3 of those 4 have the age at 21 years.
Mhm.
Which,
So that's like that was an effort made at the county too. It's like T21 is kind of like the policy stance, in that tobacco is still incredibly harmful for people between 18 to 21.
yeah, and I think a
So
lot
we
of them had
might-
a footnote about that. They refer to some act or something that is where that comes from. But I think you had to pass something else to allow you to make it 21 or something.
And I wonder if the state did that too.
So
I wonder if the state
is still, let's see, I think it's still 8.
Okay.
But maybe not.
Honestly, the county
it
has
was
a pretty
20.
strong.
Yeah, it's 18.
The county health code has a pretty solid ordinance on this. And it also, and this is kind of, my colleagues would be kind of rolling their eyes if I brought this up, but there's also a substance called kratom that's sold at like CBD stores. And there have been some instances with like polysubstance use that have resulted in death that have involved kratom.
Okay.
But it's hard to say that specific, there's just no research really on whether or not that substance has contributed or directly resulted in any sort of serious consequences. But there was a death in St. Charles. So the county council, like the St. Charles County Council and then the St. Louis County Council, created an ordinance specific to that substance. So I don't know that we need one, but like that is, I think, maybe a good model in addition to the county's T21 stuff. So I can pull that if that would be helpful.
Yeah, I think this one will take some looking at and maybe some more discussion. Something that came up, I'm on the Parks Committee, Ordinance Committee, and it's the idea of we talked about banning smoking in parks. And so it's sort of this question about where can you ban smoking? And I noticed, I think Webster's ordinance has that at the, was it Webster's or did I not put it on here? Include one of them oh no, it's Clayton.
Clayton banned because I remember watching out my office window a bunch of people protesting smoking in Shaw Park.
Well, and so on the Parks Committee is Patty DeForest, who is the director of Parks in Clayton. So she also was like, you can do it. You know, I'm like, you can. So anyway, you know, that's something to consider also adding. I don't think we have that in our ordinance. So we may consider adding something like that too. But I think this one, yeah, Sarah, if you want to find those other ones, that would be good. And we can all kind of look at it.
Yeah, I'm pulling it up now so I can drop the links in a separate comment.
Yeah, I just think if you look at these other ones, it's nice. They just have like a definition section and then they just, you know, kind of go through it. It just seems clearer than having this broken out into two. Doesn't really make sense. And then there are some like, because I was going to go through and see which ones were, you know, there's some state law, like they're matching state law and some, and, you know, like the vending machine stuff and all that. So, does that make sense for us to all kind of look at that one and revisit it, or?
Yeah.
Okay. Any other thoughts? Oh no, it's last one. Sorry, it wasn't last one. I just have that one as delete. Would be my spitting in public places. So just think delete.
Yes.
Just,
Make it go away.
Yeah.
yeah. No discussion needed there. I think delete. Okay. Wow, this is good. This is good. So next steps. What I can do is I think it might be helpful maybe to create a separate Google document incorporating our discussion changes that we can redline or show whatever.
And you can put a link in an email to us for that.
Yeah,
meeting?
I'll do it again and I'll utilize my children or Sarah to help me if I don't do it right. I don't ever work with Google. I'm so bad at it.
No, you're fine. I think what might be helpful is rather than creating a separate doc, you can change the settings on the Google Doc itself to do like a track changes.
Well,
Are you guys cool with that? I just didn't know with all the comments. I mean, I would keep this link live, but then have a separate one. I just didn't know, or we can try that and see how it goes. I just didn't know with all the comments if that would be overwhelming for people.
Yeah, well, I never saw the document, so to be able to edit it or do anything to it, that's what I was getting at. So if it is possible to set the link where I can click on it and open it in Google Docs as I do with the other commission, that would be helpful.
So did you not get? I sent a link a long time ago, so I'm guessing you didn't get it. All right. So what I'll do next time is, I thought I sent an email follow-up asking, but maybe I didn't. So I will this time, well, whenever I send a link again in the future, I will send a link and then I will send an email right after and ask to make sure people got it. And Kevin, do you want me to include give you access via your Gmail too? Just give
me access by my Gmail, because
okay.
I know that way, because
it'll work.
Something weird with like having my work account. Sometimes I can have it, but typically I think just giving access by my Gmail.
Yeah, that's how I had to do it too.
Yeah.
Sarah, do you have to do it through your Gmail too, or are you able to?
Clicked on it through the Maplewood City email, and then I think it just like
it defaults
logged in, so it just defaults, which is fine.
Yeah. And I tried like logging out of Gmail and doing it through the link to my city one, and it still didn't let me edit anything. So I guess you have to have Gmail to do, I don't know.
Yeah.
All right, so you want me to keep it on this one, or you want me to create a new one? Keep it on this one and we'll try it and see how it looks.
Yeah, let's try it. If I don't see
All
it,
right.
I'll just let you know.
Okay, and then, yeah, I'll send an email after I make the changes. It may notify you. Does it notify you when I do something on it? No? Okay.
No.
No.
All right, so I'll let you know when I make changes. And then,
And you're setting the permissions from your end, right?
yeah, and it said it was shared with you and you were an editor. So I don't know. I had that problem with the Parks one. It said I was an editor, but it wouldn't let me edit anything until I got it on my Gmail. So I don't know. Next meeting. So also Sheila had emailed me. She has a friend that I couldn't access my email. Let me see if I can read it on here without opening it. She is an attorney friend that specializes in family law, and so who is willing to come talk to us about the domestic violence piece. I don't know if we want to. I was looking ahead to see sort of where do we go from here. You know, I think we decide just to go in order. And so the next section would be curfew for minors, which I don't think would be super involved. So our next meeting, we can revisit the things we did not get to here and provide an update. Like the things I'm going to ask Chief Niver, I will put the answers maybe in the Google Doc in the comments next to where I have meeting and what we decided. I'll just put it like in italics or something so you can see. And I'll let you know. And then, so in our next meeting, do we want to just sort of finish up? We can talk about tobacco piece and then any other questions we may have about Article 1. And then we could do Article 2. I don't think will take very long. Do we want to stop there or try to start a little on Article 3?
Well, let's see what
I
happens.
say 2 and 3. Yeah.
Okay.
Yeah.
So I'll also, so this I will send out the Google Doc with, I will create a new one for Article 2 and one for Article 3, and I'll go through and see if there's state law like I did the first time and put it in the margin so we know which is subject to state law. Write a note. I got my phone. All right. So then the next question is, when do we want to meet? And we'll have to check with Sheila too and make sure. I'm thinking April makes sense at this, very beginning. Well, so I'm out of town the last week in March for spring break. I mean, hopefully. Just have to not get COVID before then, and then I'll be good.
Yeah.
Or do you, what do people think?
Sometime in April.
Like the very beginning of April, does that make sense?
I can't do the first weekend because I've got family in town,
not
but that
open
doesn't mean you
first.
guys couldn't go forward.
In April.
What about, ooh,
What about the 9th?
I'm booked. No, I think I believe the 9th might work.
I can do that because I'm out of town the next weekend.
Okay.
So Saturday, April 9th.
Yeah, in the morning. Yes.
Yeah, at 9 a.m. Does that?
I like the 9 a.m.
Yeah, it's good.
Mhm.
So I think that way that gives us, a little over a month. Can get through some stuff. Awesome. I'll send Sheila an email too and make sure that works for her. The nice thing is these are recorded too. So if, we ever can't make one, we can always watch it. And people can always share their thoughts whenever,
Mhm.
Okay, anyone have any other thoughts or things to discuss or?
You
Well, thanks,
Nope.
guys. This was great.
like it.
Yeah.
It's exciting. I'm having fun. I'm not gonna lie. I enjoy this. I
Let's
think
see
I'm gonna have to keep
if-
doing it when I'm done. There hasn't been a Sarah, you guys got to get on that and decide what happens
know.
come the end of April.
we're
Yep.
a group and don't know where they are.
What?
Not for Sarah, not know where the people, not know where they
Yeah, this is funny. I think I was technically the first council member to like email the group and try to get a meeting set up. And that was in November, and to date, I've been unsuccessful in securing a quorum for our first meeting.
Uh-huh.
So
I
I'm
do know
really jealous
Kevin
of this
offered to be
group.
on more than one committee if you were
So
volunteers.
did I.
Yeah. So
Well, I can always be
gonna have to
drafted
figure
in, I
that out.
guess, but
Uh-huh.
Yeah.
Uh-huh.
City
We
manager-
may need to in order to move forward on that one.
city manager told
Yeah.
me that your committee was filled, Sarah.
Mhm.
When I'm
Because that's probably the one you want to be on.
no, actually I'm really happy with this one.
Okay.
I'm just, I'm
Yep.
familiar with where they're going
Yes.
with that one.
Mhm.
Yes.
I can do more than
Yeah.
at a time.
Yeah. Oh yeah. So I'm gonna give it another shot and see if I can get a quorum set in the next like 7 days. I got a first meeting on the books, and then only 2 of us showed up. So that wasn't technically a meeting because 2 out of 5 is not a quorum. So
All y'all the oxen free.
Yep.
Well, thankfully, it's not a super long chapter, so you may
It's
end up getting
not,
it together
yeah.
and finishing about the time we do.
Yeah.
I mean, this one is complicated. This one is, I mean, I hope it doesn't
Mhm.
take a year, but this one is going to take a little while. Like parks, we went through all
Yeah.
of the parks in like one meeting, I mean, we're not done, but this one's a complicated one.
Yeah, but as
It
we,
is.
as we start to get a flow,
Yeah.
how we're looking these things over, I think will be,
Yeah.
I
I
think
agree.
probably be a good idea when I can see the document,
Yeah.
I'll just create a document and have 3 columns of ours and 2 other ordinances, and I can just look across
Yeah.
and see how they're written.
Well, and what I did, what was helpful is I just like downloaded them. It would only let me download them into PDF, but from the other municipalities, but then I can convert them to Word and I just compared them so I could see. I mean, it didn't take that long to kind of see. So yeah, it's just a little tedious.
I just cut and paste.
Yeah.
Yep.
Well, yeah. So
Yeah.
cool. Well, so next meeting, I'll email Sheila and make sure, and I'll send out an email April 9th, 9 a.m. We will finish up Article 1. We will do Article 2 and Article 3. And then, we'll only have 5 more to go, 6 more to go. Although one thing I noted, and this is something I wanted to, nuisances and every other set of ordinances I've looked at, nuisances is its own chapter. Like it's not, because it's not criminal and it shouldn't be criminal. So that's something.
yeah, and it also has its separate kind of
Yeah.
separate procedures as well.
Yes,
So
yes.
that might,
So-
yeah.
So anyway. All right. Well, thanks,
All right.
guys. Thanks for giving away your Saturday morning to this. This was good.
Well, it's cold outside.
Yes, it
Yeah.
is.
I'm not
At least
going
the sun's
anywhere.
out though.
That is true. That is
Oh,
true.
well, that changes everything. Yeah, the sun's out. Right. I'm still gonna look at it from the inside out.
Mhm.
Yeah.
Yep.
Yes,
All
good
right.
point. With my
Thank
coffee,
you.
my warm
Talk
cup
to
of
you
coffee.
later.
All right. Have a good
All
day,
right.
guys.
Bye-bye.
All right.
Thanks.
Thanks, everyone.
Bye.
Have a good weekend.
Bye.
Bye.